also completed a transfer summary for me, so I was up to date on the most recent kind of updates on the case, and reasons that she was transferring him to me was to do their play-based treatment.
Okay, and is it once a week intensive or twice a month?
It is once a week family therapy, once a month parent-only sessions, and individual as needed. So TheraPlay is a family therapy caregiver and child model for the most part.
Correct. Okay. Were there any resurfacing of any trauma issues recently since you started, I would say, almost 3 months ago?
Yes, yeah. So on August 14th, I met with Preston and his mother. Preston, I actually met with him individually because Alyssa told me that there were concerns about him being coached to hurt himself, and so I asked Alyssa to step out. Preston wasn't present when Alyssa told me that, and then Alyssa brought Preston out of his room into the room that they had the computer to meet with me, and then she left that area. I saw her leave in the door that was behind them on the computer, and Preston had to go get her after I talked to him. And that's when he told me that Auntie Boo Boo told him to get a nail and a hammer and hammer it into his skin.
Okay. And Auntie Boo, is that a V? V?
Yeah, V-O-O-V-O-O.
Yeah, I did spell that. Okay.
Yeah, that's how he had spelled it to me in our session. And he told me, so it's a paternal great aunt, but he described it as his aunt's aunt, right? So great aunt. So that's how he described it. And then in the following week after that, I did a TheraPlay session with him and his mom, and he demonstrated really different behaviors. So I had been meeting with him for a little over 2 months at that point, and his behaviors were significantly different. In this TheraPlay session, it appeared that he had some hyperarousal, which is a trauma response, and that is demonstrated through hyperactive behavior, difficulty calming himself. He had pressured speech. He was yelling. He's very hyper in general. He's a really energetic kid, right? It was very different in how he was talking and presenting himself was very different to me, even through telehealth, right? Sometimes it's hard to see a client's affect and to really get a full picture of their behaviors, but he was significantly different than when I had seen him prior to that, and that was a full week after his visits.
Your Honor, a full week when the same time you had the blood time?
Stacy, hang on. I'll give you time. I reserved this afternoon for this case. Okay. How many visits did you see? Was it like a one time? Was it isolated?
This was after his first visit back. After the court resumed visit, he had only had one visit at that point. Also, Judge, sorry, I do have a therapy session at 3. I was only able to block out my schedule until 3 p.m. Is it okay if I leave at that time?
You can, yes, certainly. You have to meet your appointments. Okay. So the next visit, child had hyperarousal, which is a trauma response, difficulty calming himself, speech was different, and that brings us up to date. You've only had that one visit, which...
No, I've had more sessions since then, but that is the only visit that he demonstrated that sort of trauma response.
So those following
sessions, he's had that.
No, he hasn't had that.
He hasn't had that in the last 2 sessions that I've seen him.
Okay. All right. And they're telling me that the paternal family did not get their last 2 weekend visits, I believe.
After Kirsten reported the Aunt Boo Boo incident because I'm a mandated reporter, and
Stacey, do you have a question for Ms. Hartman?
I do. This is my point. All of the abuse, all of the issues are stemming from Alyssa. and she's trying to set it up to where it looks like the paternal family, even though these burn marks occurred during her time frame. And so she does not want us to be involved in Preston's life. She's made that clear. All the way dating back to 2014, she made it clear, and the last time she took the stand on the court, with her issue that date back to 2013 with my mom, with Marianne. This is stemming from her. She's acting out, saying if you give us back our visits, she's going to hurt Preston and do this to Preston. It starts with her. It's all Alyssa.
Okay. All right. Do you have any concerns? Because the court has to decide today, Ms. Hartman, if visits should resume with the paternal family member. Not obviously, I'm not delegating my judicial authority to make decisions in the best interest of the child. I have to put piece everything together. But from the therapist's end, in terms of keeping a child or stabilizing a child, do you have any reason to believe that paternal visitation or contact is impacting the child's change in behavior? And
based on
okay, I guess I didn't want to put you in a position of finger pointing, but something obviously there's a change in Preston's life after 6 months hiatus. It may not necessarily be critically that the paternal family doing anything, but is a child, capable, whether consciously or unconsciously, with a change in behavior just with this resumption of contact?
Answer that question. You still want to make note that it was a week after my visit, a week after the visit. So that's well enough.
That's every weekend, right?
Yes, starting I think it was August 2nd.
Sorry to interrupt. Significant trauma responses would definitely appear a week later and typically longer than that, potentially 2 weeks later or longer, depending on the significant trauma reaction of the child. So it's not like bizarre at all that Preston would still be demonstrating a trauma several weeks after a visit.
And did he have the bump on his head at this point?
So this is all through telehealth, and the last time I saw him, he did not have a bump on his head that I noticed, or he did not during the hyperarousal visit.
That was the last 14th visit?
That was, no. The August 14th visit is when he reported about anti-boo-boo.
The hyperarousal, yeah.
The hyperarousal was after that session. It was another week after, so it would have been August 21st.
Wait, I'm confused. Okay, so August 21st was when you diagnosed the hyperarousal?
When I observed the hyperarousal, August 21st.
That's 2 weeks after my visit.
Yeah, and he had strange behaviors August 14th as well, but it was a shorter time with him, and he was describing what was potentially traumatic content about being told to hammer a nail into his skin, and so hyperarousal on both of those visits is not strange.
Okay. All right. Any questions from the mother's attorney, Ms. Hartman? I'm not going to put Ms. Hartman in a position, obviously, of pointing fingers. It's just the change of the environment, which the court obviously made a decision with, and Ms. Hartman and witness Whipper wasn't at the last court hearing on this, I guess, on whatever motion was then pending. I made the decision to, monitor it closely, but resumed the visitations. You saw the pictures from the visitation, and without pointing fingers, but this change in schedule and environment for Preston, we believe, has been impacted because of the resumption of the visitation without pointing fingers, but the fact that he has to visit with his paternal family.
Based on Preston's report, he was told by someone to hurt himself. So I do not know who Auntie Boo Boo is specifically, based on his conversation with his guard, with Mr. Cercio. It sounds like it was Stacy, but he didn't tell me that specifically. Based on what Preston said to me, I would recommend that visitations be stopped, at least non-supervised visits, because he's reporting that he's being coached there.
He did not disclose to Yvette Howard, the CPS worker, who Auntie Boo Boo was. Who I think already said there is a 99-year-old lady, or maybe, I don't know, the paternal family.
Preston is very difficult to build trust with. He's pretty resistant, and so it could have been a lack of trust. Children have a hard time building trust with CPS workers at times, and so he may not have trusted her in the first interview, but through maintaining a relationship and communication with her, he could build that trust and open up more. I don't know how he would, it could have been.
We've only known for barely 3 months, and he's barely known Mr. Cercio, and he made some type of statement. How old is he now? 7, 9? How old is he?
He's 7.
He's 7, right. At his age, and not knowing you for a long time, not knowing Mr. Cercio for a long time, having got a new CPS worker on the case, is that age appropriate and for a 7-year-old to, make statements or make confusing statements, make statements to please people, or would they make a statement because of the trauma? I'm not a therapist, so
it is age appropriate that he will, make statements to strangers at times. Preston has built trust with me, right? He's with his mom and me in our sessions, and he's clearly gotten more comfortable in different areas, and being able to talk to me more than he did in our first couple of sessions. And as Mr. Cercio said, he was much more talkative and friendly and open this time, and he didn't appear coached. As far as concerning visits with Yvette, it sounds like she's had one conversation with him, and so it's not that he just may not know if she's protective or not. He doesn't know who she is or what her role is all the time, and it's hard to understand that. And so he may not be sure what kind of power she has to be able to help him, or if he tells her the truth, what she'll be able to do with it. And so he could be telling false statements at different times. It kind of depends on him and his level of trust that day and with that person and how he's doing. And so he's, with Mr. Cercio and I, he's had a few months to build trust with us, whereas Yvette, he's had one visit.
Okay, thank you. It was 2:58. If you really have to just sign off and go, just hang up at any time. And we appreciate the time. Ms. Hartman.
What Preston was saying, Bobo is my grandmother, my 11-year-old grandmother. She's right here. The last time he saw her or spoke with her was Easter of 2019. She lives in California.
How do you spell her nickname?
V-O-V-O. It's grandma for Portuguese.
And it's your grandmother?
Is my grandmother, and that would be Preston's great-grandmother.
So you call her Grandma Bobo?
No, I call her Bobo because that means grandma in Portuguese. And so I call her Bobo. And that's her, the last time he saw her or had any contact was April of 2019. And she was 99 years old. How he knows that, I don't know.
And she lives in California, you said?
Correct.
And it was April 2018?
2019.
19?
Yeah, she came out to visit us.
And where in California?
San Diego.
And where?
San Diego.
San Diego, okay.
Your Honor, this is Carrie Hardick.
And I have never referred to myself as Vogo, Auntie Boo Boo, nothing. My name is Stacy, and he calls me Auntie Stacy.
Okay. Ms. Hurdick, did you want to say something, and then we'll get to some rulings?
Yes, I believe they said that there was no anti-Boo-Boo going on in Stacy earlier in this hearing. There was no anti-Boo-Boo there, or Vogo, however you say it. There isn't anybody by that name. All of a sudden, there's a grandma by that name. That's not disingenuous. There should have. Because there is no.
Excuse me, hold on a moment. I don't want to have to mute you. Ms. Hurdick, finish up, and then I'll mute Ms. Cantor.
Yeah. So I just find it interesting that all of a sudden at this stage in the hearing after there's been testimony by the therapist and CPS and Mr. Cercio that Stacy all of a sudden knows who Auntie Boo Boo could be when she said there was nobody by that name. I find that disingenuous and that there is somebody there by that name, and that puts a little bit of credibility as to what the child is saying.
True, there is no Auntie Boo Boo, Auntie Vogo. There's no great aunt that exists. I was never, when I talked to CPS, I said there was a Vogo who was my 99-year-old grandmother. There is no great aunt. He doesn't have a great aunt. And again, I've never referred to myself as anything other than Stacy.
Okay. And I do see that Yvette Howard, I believe, is still listening in on this call. And I was wondering if she had any clarification questions based on what she's heard in the past hour and a half, I presume, or hour and 15 minutes. Let us know, Ms. Howard, if you had any further questions that may assist with your ongoing case.
I'm listening to everything, and it's just a mishmash. Like I said, it just seems, again, yes, I did only have one meeting with the child, but what he told me is different than what he's telling others. And as far as this Voo-Voo, that's what he told me. It was Auntie Voo-Voo. He specifically stated that she was a 99-year-old lady, and that was his great-great-aunt. At no time did he ever state that it was Stacy. When he referred to Stacy to me, he always referred to her as Auntie Stacy. That was it. Even when he said that Auntie Stacy saw what Voo-Voo did, and Voo-Voo was the one who told him, it was always Aunt Stacy. And with the clarification, I did get clarification from Miss Stacy that it was a Volvo, but I was going with what we had in the report, which was, it was stated as a Voo-Voo.
Thank you for clarifying that. All right, Mr. Cercio, you've been listening intently on this hearing. Anything that you may have thought of or you wish to add based on, you had the one contact before you knew that you were made aware, obviously, this case was coming back to court, and so I presume you had to scramble in trying to get a interview with Preston, your client. Is that correct?
It took a couple of days to get it set up. But we managed to get it in by Friday, actually, I want to say at the noon hour. And he didn't seem much different than the last 3 times that I saw the child. He wasn't any more or less agitated. The only one that really stood out as being remarkably different was interview number 3, where he told me that he had a secret to tell me, and he made a production about telling the truth in front of his maternal grandmother, who was in the room at the time. Other than that one event, which felt coached, everything else has felt genuine and consistent with what he's told me. Although, as I listen, I think you're right. It is a credibility call, because he's telling me one thing, telling Ms. Hartman something else, telling CPS a different story. And I don't know how to... I'm not quite sure what he, as the trier of fact, is going to do with that information, because it does seem to be going in a couple of different directions. He was very quick to say anti-Roeville is anti-Stacy. Said it kind of quickly, and then almost in the same breath, I have no fear. Again, with the immediacy as before, when I said, no, she's not here, can I talk to her now? Can we go to lunch tomorrow? He seemed to want an immediate contact with her, which runs contrary to the prior statement that he made not a minute before that. So I'm like everybody else in this. I don't know quite what to do with the statements, and maybe there's an objective testing way to get to this, but I'm glad to keep meeting with them to continue what relationship I have with him. He seems relaxed with me, but
Okay.
it's a head scratcher.
You are his voice. You are to obviously report back to the court what he's, he's telling you as if he was talking to the court. So not any kind of advocacy role, just let me know if he were asked something, what would he say? What would Preston say? And
to boil that down, I asked them point blank, who's anti-Boo-Boo? Oh, that's anti-Stacy. It was that quick.
And you were able to see his demeanor on the video.
Yes.
Was it nonchalant? He didn't fidget or show any kind of hyper-arousal responses?
No, he was his usual stuff, which is, I'm going to pick up my phone. He talks to me like this. Can you see me? And he likes to play games with the edges of the camera.
Okay.
And he's that sort of playful with me, or spinning around with the chair. I'm invisible, I'm visible, I'm invisible. It's what 7-year-olds do in offices. And it was, it seemed a no-filtered response, very casual. Oh, that's anti-Boo-Boo. And then he kept on talking, can I have lunch with her? Can I see her today? So all of this ran very much in a stream of consciousness. There didn't seem any premeditation or hesitancy in his voice when he offered the information.
Bob, can I ask what date you met with him?
Just past 12.
The 4th.
Okay, so I had already sent in my motion explaining that there is no anti-Boo-Boo, whatever you want to call it. That's well enough time for Alyssa to manipulate. He brainwashes him. Even his 14-year-old brother noticed changes within Preston. He's a completely different kid. He's repeating stuff that only adults will know. He doesn't know certain people's names within the family. This is what she does. She's coaching. You made your assessment before. You also noted that he does not trust anybody. Are the counselors still on the call?
No, they had to drop off. They had at 3 o'clock.
I personally find it very unusual for a 17-year-old to be aware about trust and having trust issues. To me, that kind of speaks that somebody that he rights or whatnot. So,
those are not my words. The words that are coming from the letter are accurate.
Okay.
Right, I'm not saying you said that. I'm saying my interpretation of a child having trust issues, that's what it speaks to. But you met with him just recently. I had already submitted my opposition, my pickup order, in which I had put that information in there. So that's well enough time for Alyssa to, have him repeat what she wants him to repeat. And this is, again, the whole basis of this custody issue is she was burning him and beating him because she does not want him. She was jealous of the attachment and the bond and the relationships that Preston has with myself, Marianne, and our side of the family. And I believe it initially started with she can't control her emotions and and she gets violent, is stated in all of the previous CPS history. And now, since we started making allegations, now she copied us and is turning it around on us and coming for us to prevent us from having visits with him.
It begs the question, I have to ask this, Stacy, the question's for you. You guys waited 6 months, we were on a hiatus. I reinstated your visits, and, we're in the middle of a trial, in the middle of court proceedings. It begs the question, you get your visits reinstated back. I mean, I'm a common sense person. I would say, well, let's just show as much fun as we can, have a lot of fun with Preston and show him, a lot of love and catching up with the family. You know what I'm saying? Well, it begs the question, and I get it. I get all the finger pointing and going back and forth, but you just got your visitation back, and you're pins and needles. Obviously, you just want to make everything fun for Preston, etc. And how soon did you find out the CPS was knocking on your door, calling you?
Exactly. We got our visits back. We were happy to see him. We had fun that day. Approaching my next visit, I believe, actually I didn't find out, CPS didn't call me until recently, but Linda Lay called me, I think the Thursday before I was supposed to pick Preston up. So that's almost 2 weeks after my initial visit, this allegation comes out. And tell her this.
Okay. Right. Begs the question. You just got your visitation back, and then an incident happens, and then a lot more finger pointing is happening. That, or Preston has a imagination, but it doesn't seem in line with when the therapists are saying he exhibited signs. But I didn't get to ask the question. The severity of the hyperarousal traumatic responses. It appears that my finding today is there was one showing of that, and because I guess Mom and her attorney stopped the visits, obviously there was no more showing of the traumatic responses, and that's the problem when you have you have court and then you have the child's mental health. So you have to, I guess, do what you do, or the other side has to defend, and then they want their compensatory time. Based on what I'm hearing, Hannah Hartman, I guess, her last statement, the purpose of today's hearing was to recommend supervised visits, but I'm getting a contradictory statement from Mr. Cercio saying he said it was Auntie Stacy, but when can I see her again? So, no doubt, if you haven't seen the child for 6 months, you're going to plan a lot of fun activities for the child, a lot of bonding and catching up with the paternal side of the family, and so they're not just going to sit around the house, they're going to be planning lots of activities for him. And I need to ask also about his schooling. Mr. Cercio was of the impression that he's not attending his virtual school. And then I'll get to today's rulings and we'll wrap it up. Let's on the school question, Ms. Hurdick, is Mom on board with the virtual school?
Good afternoon, Your Honor. Linda Lay. Right now, Alyssa is homeschooling with Preston, so they have a set schedule. It's on time for learning. It's on time for learning, so it's not the traditional through Clark County.
Time for learning is the program.
Time for learning, and also the Capital City with homeschool as well.
All right, did I get that right? Time for learning program? No. Do you have to be certified by the Clark County School District?
Yes.
Mine is applying for certification for homeschooling. And how long does that process take, Alyssa, to get the certification for homeschooling?
I already have it. They sent it to me last week.
All right, correction. She has, you said letters of intent, but do you have an actual certificate?
That's what they're called.
Oh,
That's what it's called. It's called a letter of intent to homeschool. And I have to keep it, the records to prove that I can have permission to homeschool.
and he has to take standardized tests at the end of the year or mid-year?
It's going through the time for learning. So every week there's an activity report that prints out, and I have to keep all the papers that he does at home because it's halfway online and half offline. So I do it this way because I have to work too, and I can't keep up with CCDC and do it at their time, and I still be a single mom that works. So this is the best way that I can do it to still put food on the table.
Okay.
I would be happy to take him 1 week on and 1 week off since she's not able to help him with his schooling. I can.
I'm helping him with his schooling.
I understand. I don't think the schooling issue is going to impact the court's decision. Trial is set for when again? Did we get you guys your trial date? It should be. You don't have it assigned yet?
Oh, not yet.
There is a court date. I think we're holding that today already. The status check on visitation reports of the GAL and therapist, September 17th at 9 a.m. Jeffrey Ann and the courtroom, we're going to vacate 9/17, and we need to assign a trial date. We are in the middle of the trial, and so we are still, I believe, in Mom's case in chief. How much more left do you have in Mom's case in chief before Stacy and the grandma, I guess? Well, Stacy, it's her case.
I'm chief of case, or however you call it.
Oh, I'm sorry. When Miss Barnes started the trial, Carol Barnes started the trial for you guys, right?
Correct.
So you're still on. How much more witnesses? How much more questioning? Just a rough estimate so I can assign trial days immediately to get this thing back in the trial.
So neither of the paternal family has taken the stand. None of us have taken the stand, so we still have to go through that. If there's help witnesses, I know she had people from her church she wanted to call as witnesses.
They have to have already been disclosed.
Another question.
Were they disclosed in the list of witnesses that Miss Barnes had filed before trial started, Stacy?
Yes, they did file them. Are you still calling those witnesses, Linda?
Your Honor, I think with this matter, I think we're on day 5 trial, and we kind of move things around because of the therapist and with the detective. I never finished my case in chief with Crystal Whipple. I think we allowed...
Yeah, we left off there, yes.
Right, yeah, I think Ms. Barnes was going to question it. I think we were trying to question all at once, that way we could release the witness. So,
Yeah, we took her out of trial, basically. She was your witness. Christopher Whipple was your witness.
right, and now that we have Ms. Hannah Hartman, I think I need some time, and then, so wait, 2 hours?
Who's already on the stand? There's only asked me any questions. Yes, you're on.
I apologize, I think because of the lapse,
We took her out.
we took Alyssa Plummer off stand and put Crystal Whipple on the stand. And then this all happened in February, where it was continued. So I don't think, so I'm waiting a full day. Because we still have this.
Oh, it's more than, I think paternal grandmother and paternal aunt are going to take a full day. Mom's going to take another half a day. And then you're looking at Miss Whipple, now Miss Hartman, and I don't know if CPS workers are going to be, and then the church witnesses. I say 3 full days. 3 full days. And that doesn't include closing arguments, which should be, depends on what the new judge will schedule. For me, closing arguments are about a total for both sides about 90 minutes, 45 minutes each side, which includes rebuttal time. And of course, you have Mr. Cercio, who is going to testify as the child's voice. So let's assign those trial dates. And then I'll get to the order. Okay. Anything else you want to add, Mr. Cercio, since you just sort of popped up on the video here, you came up on my screen, and while I'm looking for trial dates for them?
No, just set them and I'll be ready for you.
Well, we're not as bad as some other judges who are setting out a year out now, because COVID has backed us out 6 months. We're doing pretty well. We're settling, I think, April. Unless I have one, I can look in March and see if I have anything 3-4 days. I don't know if it'll be 3 days.
May I suggest keeping it in April, because I'm not certain whether or not the family law section will have a bishop conference this year. And I just I'm sorry, 2021. And that's beneficial for all family judges and practitioners. So I'm not sure what speaking engagements I may have to do.
Let me both sides as well. We're going to have a total rearranging of cases in family court. It's going to impact all of the cases. First of all, we're getting 6 brand new judges, and 4 of them are going to be doing domestic cases like myself. And you have to create a caseload, a calendar for them. So there is a more than higher chance you might not stay Department I, or whether, that's 2 females running in this department. Or you could be into one of the new departments. It's either UVWXYZ, and one of those 4, well, there's 6, but 2 are going into abuse and neglect, last I heard. So if I set you in April, then a new judge, wherever you'd be assigned to, if you change out judges, is going to rearrange their entire calendars. But, what you want to call, I suggest you call that new judge's secretary and say, hey, don't kick us out of April. We've been set in April if you want to rearrange it to somewhere different days, but, this trial is one of those unfinished trials, and it has to be, and hopefully by April, COVID will be beyond that, where we're back in the courtroom doing the trials. I won't be though, because I'll be off the bench by then. I'll be retired. So, what do I have in April? So what I do is I'm just going to go ahead and set you guys for the 3 days, and Jenny will do an amended order setting trial, and it looks like, might as well, I can, let me see. Yeah, we would have to lose some days. 3 days is tough. I could probably get you the 2 full days. Anything you don't finish up, the judge would have to set you for that final day. And so you could just let the new judge know. We'll probably won't get it done in 2 full days. But I can't, I will give you 2 days, which would be, it looks like April 21 and 22. And you may
we're trying to check. We think we have another trial on those 2 days. We're just double checking.
Okay. Well, then that would put us out into May. And like I said again, the judge may rearrange their whole calendar. If you agree to May, then the lowercase dates,
the lowercase dates, the other trial is April 8th.
So 21 and 22 only two I can give you. All right, I'll put that in the chat box. Let me write that in the chat box. And they both will start at 9 a.m. I don't know what the new judge will do, but it's 2 full days, and you'll continue on. And it has to be done in person, be able to confront all the witnesses. Okay, so the court made inquiry with the schooling. There's no impact with that. So here's the thing. There's a lot of there's not a lot of trust going on between both sides. It's understandable. The level of conflict is very, very high. It's one of the factors that we look at in best interest of the child, given that the child is still going through counseling and therapy. I don't think he has the maturity to, and I'm making these as findings. Child is, I have to put it, let me write that down. Child is not of sufficient age or maturity to state preferences. That's why I was signing him a GAL at age 7 in terms of his timeshare. So that's one of the things I gave consideration on. There's been new allegations of what do you call it? A child describing not wanting to self-harm himself. Okay, CPS has ongoing investigation. GAL gave you have a written report, I guess a verbal report from 9/4 interview.
From the GAL?
Yes, yeah, he got a report today, right?
Yes, if you desire, I can put that into a letter format.
All right, CPS wasn't able to identify alleged perpetrator, as it speaks to basically Aunt Stacy. They said Aunt Stacy was Aunt Stacy, which is opposite. Is that the word? Not opposite. Opposite. To GAL's report, and I'm trying to recall if Ms. Hartman stated that the child disclosed to her that Aunt Stacy said that, or she couldn't identify who, or the child said it was Aunt Vuvu. Let me go back in my notes. I don't think Ms. Hartman, did she say anything about any disclosures to her? No, I think child told her about Auntie Vuvu, but it was a paternal great aunt, his aunt's aunt. So I've got GAL saying it was a disclosure of Aunt Stacy, and I've got CPS and Ms. Hartman saying the child didn't disclose it as Aunt Stacy. So it's kind of 2 out of the 3 that kind of conflicts with the GAL's report. And so CPS wasn't able to identify alleged perpetrator, which is opposite to GAL's report, and Ms. Hartman Ms. Hartman did not state child disclosed. It was Aunt Stacy. It was a paternal great aunt. So I got 2 saying no, we couldn't verify it was Aunt Stacy, and I've got 1 saying it was Aunt Stacy. Now, I have to give some weight to this. Ms. Hartman, I reminded her I'm not delegating my judicial authority, but she stated I would recommend, from a therapist standpoint, that there would be supervised visitation, not complete lack of contact, but she recommended supervised visitation between Preston and his paternal family out of concern that hyperarousal and traumatic responses may resurface again. Well, here's the thing. The mother and her attorneys filed the motion, so we weren't able to see if, and they did what they had to do. I understand that, and might have been with talking with the therapist as well. Look, the child had traumatic responses, but it appeared to me that traumatic response was on August 21. I assume that no visits took place between the paternal family. After August 21, there was only the one visit on August 7th. Stacy, you had to visit August 7th?
That is correct, Your Honor.
So you anticipated to get a visit on August 21 every other weekend, and instead Preston is seeing his therapist on August 21. And they had suspended your visitation. So we have one visit. We didn't. I don't have facts about what happened with the second visit. What happened with the third visit was a new allegation. We'll never know because Mom filed her motion, and I'm not faulting her for that. And the therapist, I just don't know if I'm persuaded enough to say, because I didn't ask the therapist the severity of the hyperarousal, but I'm assuming any type of clear symptom of hyperarousal traumatic response, difficulty calming oneself, has brought back feelings of or memories of trauma, and no matter the spectrum of severity, trauma is purely, that's what it is. Trauma is trauma, and trauma is not in the best interest of the child. So as far as the visitation goes, I could defer to the therapist's recommendation, not complete lack of contact, but some type of, well, it's my discretion. Should it be supervised, or should be something lesser than an overnight on the weekends in terms of that. Now, competing with that, the GAL reports child is not scared of Aunt Stacy. Child wants to have more time with Aunt Stacy. When are we going to lunch? And, what are we going to do next? So, I think I have to give that some weight as well. So balancing these views, okay, let me add some to this. GAL, however, reported child is not fearful of Aunt Stacy and wants more visits. Miss Hartman recommended supervised visits. Okay. Court finds there was some type of traumatic response from Preston. The severity is not as important as the fact that trauma is trauma. Okay, so here's the court's decision. Court hereby orders on a temporary basis. We will go with, let me see, court hereby orders on a temporary basis. Based on, yeah, go ahead.
I'm looking at my table of contents for the CPS book, and on January 31st, we have on date stamp number 984 through 986, also on 825, CPS says Alyssa's allegations are untrue, people don't exist, and she is coaching Prestons. This sounds like the exact same thing. And throughout this...
What are you reading that from, Bruce?
This is one of the CPS reports from January 31st, 2017. I took the liberty to go through all of the CPS book and put together a table of contents. I can send this in to you if you'd like to review it.
From the trial exhibits, you may actually have some of those CPS records. Okay.
Trial exhibits, yes.
Yeah.
all of these, it's a cycle, it's a pattern. It's the same exact thing, different accusations against different people. The accusations go against whoever's trying to get custody of her. Again, as I mentioned, it started with Sean. All of these different allegations on Sean. CPS has mentioned a few times that it's custody motivated. I think when I met with Yvette, she had the same idea, because Alyssa did ask her if she can make the recommendation to cease my visits. I will send this in to you so you can review it. It's a pattern. It's a pattern all the way back from 2013, 2016, 2017, and then from Sean it moved to my mom, and now it's on me because I'm the sole person going for custody against her. Now, in regards to what Preston is telling his counselors, I have nothing to do with that. I had 1 weekend with him. We went to the lake. We had fun. The family was around. We had a lot of family time. None of us are here to tell a child to hurt himself, especially with the reference of a hammer and nail. To me, that kind of reminds me of like a Jesus on a cross, who Alyssa is very religious now. In fact, I think her license plate says Jesus. So again, this will come to her. This is not something that a 7-year-old would make up on his own. She's using this because, the counselors have met with Preston via Zoom. Nobody's checking his back. Nobody knows. Preston has told CPS, police, me, numerous people that his mom has hurt him. And since nothing's being done, he's not going to continue to go against her. What choice does he have? He's a child. If he doesn't, then the abuse gets worse.
Your Honor, may I say something? Ms. Herdick.
Yes, you get the last word. It's your motion, your final rebuttal. I think I have a question I had for Stacy, but I couldn't remember it just right off the bat. But go ahead.
So for 6 months, this child had no visitation with paternal side. He went from a trauma therapist to role-playing therapist. They moved him down in therapy when we all know that we had to stop the trial because there was evidence that we could not disclose to them, and the court was not to disclose. We were told not to disclose, and I don't want to go past that, as to what was happening to the child at that point. And that was why there was such a drastic stop of everything, and the contact was cut from the paternal side. At that time, there was nothing that has happened to this child for 6 months, except that he's improving. All of a sudden, they start visitation again, and they're going to say mom's creating it again? I'm sorry. That doesn't even sound right. 6 months he's been improving. Gradually, he's been improving. He went from a trauma therapist to a normal role-playing therapist. Your Honor, if you're not stop. When it's your time, you get to talk. Excuse me. Your Honor, can you mute her?
Stacy, I will ask you to wait. I know you want to say something in response, and once she's done, you can ask me if you're allowed to respond further. Okay. I heard that, yes, he got better after it stopped, and when it resumed, it got worse. I think that's basically Mom's argument. That's clearly in her paperwork, so I really... I thought I might be wanting to say something else new that I might not be aware of. But yeah, I read that in the paperwork.
Okay. But I'm not just saying that. That's the therapist that did that. And I don't think that the court should allow anything that is not supervised. I do not believe that is in a child's best interest. And so you need to look at that. This is very contentious on all sides, but I'm sorry. It is not in the best interest of this child to have unsupervised visits with them.
I actually thought you were going to respond to the nail and hammer referral that Mom is religious and talks about the crucifixion of Jesus or something with Preston and referencing a nail and a hammer. That doesn't come from Stacy's household. Maybe
I'm sorry, Your Honor.
That's what Stacy...
They say what's convenient to them. And I don't believe that that's a reference to Jesus nailing himself to the cross. He can say whatever she wants, but that is not a reference. He never said anything about God. He never said about anything that would have referenced God. So, I'm sorry, that's a red herring she's throwing out there because she knows Mom is religious, and mom does have beliefs, and the child goes to church. But I'm sorry, out of the blue, the child comes up with this. I totally disagree and do not think it is in the best interest of the child that he should be non-supervised visitation with them.
Okay. Stacy, I guess this is the part where you asked me, can I add one more thing? Which, go ahead, you can.
Yes, I would like to say, again, Preston has been seeing the counselors via Zoom. If he was to show traumatic experience with us being out of the equation, then obviously that would fall on Alyssa. So the abuse, and the reason why she was, as Crystal told me, mentally unstable is because she felt that she was going to lose Preston. So all of the emotions, all of that stems from Alyssa. Again, even when I did have my visits, it was only every other weekend. That's 2 days. She has him 24/7, and now he's not even going to school. He's not seeing anybody in person. Nobody can speak to whether if he has burn marks on his back or not.
And that's I remember I was going to ask you, you have this counter motion to have Preston be seen by a different independent type counselor. I'm not, and that's your concerns of bias. I don't find any bias in terms of Whipple and Hartman. I think they took an oath. They have a license to do no harm and to do what's best for the child. And they came from a CPS referral, so it's not like mom knew them beforehand. She sought them out at the CPS suggestion. They work with a lot of abused, neglected kids. They work a lot with CPS cases, and they take a lot of CPS referrals. So we have to trust them in terms of their licensure to act ethically and advocate for the child and do no harm to the child. So the motion for a different therapist is denied. However, since there was a change of therapists, well, not a change, we call it a transition from trauma to therapy for the attack. Mom also, it's the writings on the wall there. Mom also has attachment therapy she has to go through with Preston because, given Preston's, behavior and conduct sometimes, it's needed. Obviously, it's not that they have, it's hard to describe it, but basically, Mom and Preston are needing therapy for attachment therapy. There are some possible bonding concerns as well. It's probably based on the history of being previously under Sean's primary care and now in Mom's primary care, and so they felt that was the need to do the attachment therapy there. But the question, again, is, okay, if the paternal family has a prior history with this child, have they ever rejected you, Stacy, in terms of, attachment therapy for you and Preston, or they never explored that? And if they work for Alyssa, if they work for Preston and helping Preston get a better relationship with his mom, more bonding, more attachment, where does paternal side of the family, fit in? Well, that's the whole issue of the trial itself, the visitation rights, and the statute works kind of backwards. A parent has a constitutional right to withhold contact, and that withholding of the contact is presumed to be in the best interest of the child, unless the parent is unreasonably denying the contact. And that is a definition that the court has to work through, and that requires a trial, finding credibility and witnesses whether or not this type of withholding is in fact the best interest or unreasonable denial. And so that's what this trial is going for, but it's also because of the lots of the fingerprinting, the credibility issue, it causes stress for everyone in terms of not just visitation. If the court does not find mom credible, it's possible custody might not be in Preston's best interest with her. But would it go to, Aunt Stacy? And what are the rules in terms of, a hierarchy, biological natural parent over a next of kin related